Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrot. Thank you for joining us for another episode of Angeion's Leading Litigator series. Today joining us is Joe Siprut. Joe is the managing partner of Siprut PC, and it's our pleasure to have him here. Thanks for joining us, Joe.
Steve, the honor is truly yours, so thank you for acknowledging that.
Joe, you do a tremendous amount of consumer class action work. So that we keep seeing coming up are how coupon or voucher settlements are being treated under CAFA. Do you have an opinion? Do you have any advice to practitioners in the area how to deal with that issue?
Yeah, it's an important issue because now more than ever, the hazards exist. When you're putting these settlements together, if you are approaching the coupon voucher line, you're potentially encountering problems. And even if you're not ultimately torpedoed, you're encountering issues that you're going to have to argue and debate, and so that increases the cost. So there's no doubt that this is an issue to be aware of. I think that most people who are structuring a settlement today have an awareness that this is a hazard that's out there, and so it's unlikely to be something that we'll see a whole lot of in the future. I think what has happened, some settlements got sort of caught in the transitional period when they started negotiating deals, the parties or the lawyers, that probably weren't anywhere near the CAFA coupon line, a year ago. Right. And then throughout preliminary approval and so forth, the law continued to evolve. And so we've seen some interesting cases. Of course, in my situation, I've got the Southwest Airlines case. We were lead counsel in that case, and whether the settlement there is a CAFA coupon settlement is an issue that the Seventh Circuit now has under submission. And when we structured the deal, we argued it was not a CAFA coupon settlement because drink vouchers or drink coupons, that was the underlying issue in the case. So if you give back to people the very thing that was taken away, we thought it's pretty clear that's not a CAFA coupon settlement, but because it does in the end involve coupons, there's an issue that the Seventh Circuit has now, they're going to have to decide that. So those are the kinds of things that I think are still out there.
Got it. Great. Thanks. Joe, you're the managing partner of a large law firm that does a tremendous amount of class action litigation. Given that the Supreme Court has given increased scrutiny, and indeed the circuit courts and the district courts as well, to class action settlements and class action issues in general, how do you hedge against the risk of a potential onslaught on Rule 23?
Yeah, it's a great question, and as the managing partner of the firm, I have the luxury and the responsibility, I think, of thinking about issues like this, hopefully at a deep level on my better days. And so, I think that this is an important question. Our business model is to solve that problem through diversification. It's not unlike a stock portfolio. I'm not, a huge finance or stock guy, but I imagine that on a basic level, there's a direct analogy there in that, if you put all of your money on one particular stock, it may go up, it may go down, but it's incredibly risky. As you invest in a broader cross-section of stocks, mutual fund that follows, one of the indexes or something like that, then you've got diversification and with that risk management. And so in the same way, I think of the case portfolio of the firm as having a risk hedge from diversification. That's true not only in the class action space, but also outside of it. I mean, our firm, for example, has many commercial litigation areas. We do patent litigation, we do False Claims Act litigation, we do more traditional corporate litigation, Company A suing Company B. We might have the plaintiff on a contingency, but it's still commercial litigation. And then we have our core class action practice, which is probably 70% of our overall portfolio. But the point is that there's a lot of stuff in that pool. So it's unlikely that we're going to get killed in all areas at the same time. And in the class action space, we've got lots of consumer stuff, but we also have less traditional consumer stuff, like the NCAA concussion litigation. Sure. So, we try to hedge against these inherent risks, I think, by being diversified. And to support that caseload, we hire people who have great litigation skills, who can handle those different areas. And that's also a philosophical belief, I think. 80% of all litigation, no matter what area it is the same stuff. Right. It's the same toolbox or the same skill set to survive in all those areas. So it doesn't matter if it's patents or class action stuff or personal injury stuff. You have to know how to be a good brief writer. You have to know how to be an effective oral advocate. You have to know how to settle cases, or at least hire people who know how to do those things.
Sure.
And, that will get you a long way in each of the areas. And then for the 20%, where you actually have some specialized knowledge about the issue that's important, then, you need adult supervision, and that's okay. We have partners at the firm who handle that as well.
Right. Great. Joe, I'm going to choose to ask you about another example of a case that I know you recently litigated before the 11th Circuit involving pick-off issues, named plaintiff pick-off issues. Can you give us the benefit of the history of the case and the resolution and how it essentially created a new doctrine?
Yeah, one of the things that we're seeing nowadays is attempts to pick off the class representative plaintiff. This dates back in large part to the Seventh Circuit's decision in the Damasco versus Clearwire case. It's a couple of years ago, and the effect of that opinion is that if a plaintiff has not filed a class cert motion and receives an unsolicited settlement offer that purports to offer full relief on an individual basis, the Seventh Circuit said that that person's claim will be mooted, it will be terminated. And that's a very complicated ruling because the regime it creates is one in which if you're a plaintiff, in order to prevent that from happening, you have to essentially file a class cert motion concurrently with the complaint. And, if you don't do that, a defense lawyer who knows the law will immediately try to pick off your plaintiff. And so that's a little bizarre because the last time I checked, the appropriate time to be debating and briefing class cert is after discovery, after an evidentiary record. And so it's odd, to say the least, to be filing a class cert motion, and then in your motion you say, but don't really rule on class cert just yet. Let us take discovery to support it. So this debate has played out in various circuits across the country. We have now just recently become involved in a case that was in the 11th Circuit we became involved after the person had been picked off, and the trial court had decided that they didn't file the protective class cert motion. That was it. The claims were terminated. The case was over. We took it up to the 11th, and we argued the case before a very hot and very interested 11th Circuit panel. And the decision that the 11th Circuit gave us was extremely favorable. It was a complete victory on this issue in every respect. And the best part is that not only did we turn it around, but they created really good law. The 11th Circuit has now issued what I view as the anti-Damasco opinion that's now out there, which says, no, Damasco got it exactly wrong. The filing of the protective class cert motion that's not going to be the distinction. If a plaintiff files a class case and it's still a class action and the defendant tries to send an unsolicited offer, even if it's for full relief, the claims will not be mooted. So very important piece of the law.
That's great. Joe, thank you so much for being here. Your unique perspective was invaluable, and we particularly like the real-world examples that you shared with our viewing audience at home. So thanks.
That's my pleasure, and thanks for having me.